Florida Builds Incorporated. Counsel, if you're ready, you may proceed.
First off, my name is John Middleton. I'm not Adrian Middleton, who's my son sitting next to me. He asked me to argue this. I did file a notice of appearance April 5th. It should be a record. I know the court knows, first off, may it please the court and counsel, I know the court knows the facts of the case, but there's just certain facts I want to point out because I'll be referring to them. One of them is, which is most important, that there was a timely notice of appeal filed on the foreclosure judgment. Now, granted, that's at the same time there was a motion for relief from judgment filed on this at the same time. And the reason I point that out is because in this case, the appellant has raised the issue of the legality of the contract. And the reason this is important, because we're putting a lot of emphasis on 1.930, I get that. I'm going to talk about that.
Didn't your client effectively, not effectively, as a matter of law, accept the facts alleged in the complaint when she was defaulted?
What was that, sir? I'm sorry now.
Your client was defaulted,
yes,
right?
Absolutely.
And so, and under existing law in Florida, that means that she accepts all the facts as alleged in the complaint. Those facts are established as a matter of law.
Your Honor, I realize that she was defaulted, but the illegality of contracts on public policy can be raised as fundamental error at any time, according to the case law that I have. And what's the important is that?
Well, wait, hold on. Just to get, we'll get there.
Okay.
Just trust me. Just one step at a time. So you acknowledge that she
Yeah, sure.
effectively admitted to the facts by
Obviously,
being
I do,
defaulted.
Your Honor.
Okay. And that judgment that the court entered was on that default, basically. I mean, they called it a summary judgment. It really should have been a default judgment. Do you accept that as well?
I cannot disacknowledge that, Judge.
Right. So when you filed the notice of appeal, or when counsel filed the notice of appeal, what was the good faith basis for attacking that judgment at that point?
At that point in time, Your Honor, we at the same time filed a motion to set aside the judgment based upon the illegality of the contract.
Right. Which you could do even without filing a notice of appeal.
And the point I'm making to you is, Judge, that issue can be raised at any time. If it is in fact fundamental error, it can be raised at any time, including, in my understanding of the law, is that even if we didn't raise it, this court might see it and say, you know, that you have fundamental error here. I have case law to that effect that I could like to cite to the court.
But maybe before we get there, could we just talk about jurisdiction? You know, the order denying the motion to set aside, did you file a notice of appeal on that?
I'm sorry, ma'am.
Was there a notice of appeal directed to the order?
There was not a notice of appeal directed toward that, Your Honor, and I'm, like I said, I will get to that issue, which is the 1.930 issue that you instructed us to be prepared to argue, and I ain't prepared to argue that. The only reason I bring up the fundamental error issue is if it's fundamental error, it doesn't make any difference that we didn't file a notice of appeal in the 1.930.
I think you're looking for 9.130, but so what you're saying is we can have jurisdiction, if it's fundamental error, it matters not if we have a notice of appeal before us.
Since there was a notice of appeal filed on the judgment, the final judgment, you have jurisdiction on a fundamental error in that final judgment if there is one. That's what I'm saying.
In the final judgment, based on the record in that case, correct?
Well, Your Honor, I think I understand where you're coming from, but the issue was raised before the court, before the lower court. It's been briefed by both parties, and so it's not like it's an issue that was unknown to this court or to the lower court.
But do you acknowledge what the chief is asking, that the order that I think you want to get to, the order on the denying the motion to vacate the judgment, or the order denying motion for relief from judgment, is a separate final order?
Your Honor, I think that if you, the little reading of the rule to that, the answer to that question is yes, Your Honor. But at the same time, if you look at other cases and look at, for example, the Florida Supreme Court has said that these rules aren't supposed to be gotcha rules in the procedure. If you look at cases and look at
But
other.
nor are they designed to expand our jurisdiction when we don't have it, are they? I mean, we can't on our own create our own jurisdiction by looking at orders and judgments that are entered after the notice of an appeal unless there is specific authority.
There are cases out there, Your Honor, where there's premature notices of appeal filed, and you're probably well aware of them, I'm
Right.
sure.
And there are rules that govern that, yes.
And there are cases where the wrong order was mentioned in the notice of appeal. And I think there's a case before this court, I have a few cases that I brought with me, again, having to not write a brief on it, but to just come up and talk about cases. But in the case of, excuse me, Duran v. Stadler, case 686 Southern 2nd 627, in that particular case, the notice of appeal designated the wrong order that it was appealing.
You're not arguing to this court, are you, that you designated the wrong order?
I'm not, Your Honor, I'm saying that we filed a notice of appeal, and in that notice
And you knew
of
the
appeal,
order
we
you
were
were
going after the
appealing.
final judgment. Yes, ma'am, I understand. But what I'm suggesting to you, that if you look at this particular case, that this court could consider that notice of appeal a premature notice of appeal when you're looking at the whole context of the case. And that is that when we filed that, at the same time, we filed a motion for relief from judgment. I'm suggesting to the court that notice of appeal could be construed as an appeal after addressing the order on the notice. That's what I'm suggesting.
Can you, well, and I understand that's what you're suggesting. Can you provide me any authority for that point? Because I can tell you 14 years on the bench, I'm not sure of a case where we had final appeal authority over a final order, and then you had a subsequent final order that was not separately appealed where we exercised jurisdiction.
I will, if I may, Your Honor, there's 3 cases that I'd like to cite to the court.
Sure.
All right. And one of them is Bass v. Jones, which is a first ECA case, 511 7 2nd 441, 1987. And in that case, it was a premature motion for rehearing on a non-final order, and the summary judgment order eventually, the final order eventually entered on that case.
Again, let's talk about, I'm talking about final
I
appealable
understand,
order
Your Honor.
versus final, not premature. Okay.
I understand.
Okay.
The other case I just cited to you, which was the Duran case, in that case, the order was, that was appealed was designated wrongfully in the notice of appeal, and the court said, no, we understand it to be taken for this particular order. There's also the case, Your Honor, of Angrand, A-N-G-R-A-N-D versus Fox, D-O, and the site for that is 552 Southern 2nd 11-3, and
I'm sorry, 552 Southern 2nd,
I'm sorry,
11,
552 Southern 2nd 1113,
Thank you.
1013, I guess, 1113, whatever. But in that particular case, Your Honor, it goes into discussion about the premature notices of appeal, and it goes in talking about the Williams case, which is a notice of appeal prematurely filed before reviewable final judgment deemed to hold over and attached to a later judgment. And so, in other words, by analogy, I'm suggesting to you that, granted, the notice of appeal was filed to that final judgment, but at the same time, there was a motion for relief from judgment, and the final order entered on that is in essence, an extension of the final judgment that was issued.
Well, and let me just make sure I've understood the authorities you've cited to me. It seems like the ones you've cited to me deal with 2 cases involving premature appeals and one involving an order or judgment that was erroneously identified. But you have not cited to this court a single authority where you had an appealable final judgment and then a second separately appealable final judgment where a notice wasn't filed, but the court exercised jurisdiction.
Your Honor, I understand the court's position on it, and I acknowledge the fact that reading the rule, that's what it would appear that would be required, that we would have to file a second notice of appeal plus a second filing fee if the court did not construe that as a premature notice of appeal. I understand that, Your Honor.
well, it could have been one filing fee if you didn't file the original notice of appeal. I mean, if you didn't file the notice originally on basically a default judgment and just focused on seeking relief from that judgment, it would have been just one filing fee after you had that resolved. It would have also saved you the trouble of filing a motion to relinquish jurisdiction with this court, right?
I understand the court's position on that.
Yeah.
I do, and I'm telling the best I can do from the
Sure.
case law that I found, Your Honor. Our position would be that the court could construe the notice of appeal that was filed on the final judgment as, and in view of the fact that we filed another motion with it attacking that judgment, that it could be construed to, really what we were going for was the motion for the relief from judgment and the issues raised in that motion.
What did,
And
oh, go ahead, please, I'm sorry.
okay, and the only reason I say that, Judge, is that, you know, we are putting procedure over, form over substance in a way here. And the reason for that is that, you know, this is an issue that this court raised. This is not an issue that the appellee raised. This is an issue that this court raised, and I understand it. But at the same time, everybody has briefed this issue, the lower courts ruled on it, and there was a timely notice of appeal filed at that point in time, and it.
Well,
based
and let me
upon-
pause there. Do we or do we not have an obligation to determine our jurisdiction in every case?
Say that again, ma'am?
Do we or do we not have an obligation to determine our jurisdiction in every case?
Yes.
Okay,
Yes,
thank you.
ma'am.
Is a notice of appeal jurisdictional?
Sir?
Is a notice of appeal jurisdictional, like the order that you attach to a notice of appeal?
A notice of appeal is jurisdictional except for in those circumstances sometimes, Your Honor, where like an order is misnomered in the notice of appeal. The court will look at it and say, oh, well, really, if you look back, they meant to appeal this particular order. And that happens. And that's, I think, it happened in the Bass case, if I recall. But what I'm suggesting, I acknowledge the fact that it is jurisdictional as far as a notice of appeal. But once you have a notice of appeal filed, it can be, you can look at it to determine whether or not it's prematurely filed. And it's not really attacking that order, but you're looking at that the motion for relief from judgment and the issues raised therein. So that's my argument I have to make in response to this court's order, and that's what I've done and the case law I've cited.
Do you think there's a tension between 9040, which says that we have jurisdiction necessary for complete determination of the cause, and 9110H, which talks about scope of our review? It says that we can review any ruling occurring before the filing of a notice.
Well, Judge, I understand under 1.110, they specifically refer to a circumstance of the premature notice of appeal when you have a rehearing motion. And I think that's what you're getting at, I suspect.
Sure. Well, I mean, and then also 9110H talks about multiple final orders, assuming the notice is timely as to each of those final orders. Are you basically arguing, well, I filed a notice of appeal with respect to one final order, but I now want the court also to look at another final order that notice of appeal was premature?
And that's what I'm suggesting, Your Honor, that the court has the authority to do it based upon the circumstances in this case. And that is where everybody thought that we were coming here at one point in time to argue the issue on the court denying the motion for relief from judgment. And then, and here we are not arguing that. We're arguing something this court has brought up as a jurisdictional issue, and I understand that. But I think that based upon the interpretation of these cases, that if you look at it, Judge, I think you can at least see where there's an argument to be made that this should be considered a premature notice of appeal on the order denying the motion for relief from judgment.
Well, on the 1540 motion, we'll spend a little bit of time on the merits since you're here. Is the primary basis of your argument that the trial court didn't have an evidentiary hearing before issuing the order?
Yes, Your Honor, one of the motion to correct a motion for relief from final judgment was a very detailed motion of why this was an illegal contract.
But without any attachments. I don't think I saw any like actual affidavits or documents attached to it.
Well, no, but under, as my understanding of the law, Your Honor, from the cases cited in the brief, was that even an attorney's affidavit or whatever, it's just the issue whether or not you present a colorable ground. not the evidence that you present with it. That's what my understanding is based upon reading the briefs and looking at the law that was cited therein. In other words, if you make a argument to the court that it should be, and make factual allegations, if there's a dispute about the facts, sure, you should have an evidentiary hearing. And that's what I think that we were entitled to upon the filing of, if the court considered the motion, obviously, it wasn't just denied, it considered the arguments of opposing counsel, but did not, the facts, in my opinion, are somewhat in dispute. I mean, for example, did this person have a contractor's license? They make the allegation in the motion that this person, this corporation, at the time they entered into the contract, wasn't even a corporation.
Right, but what evidence did you submit with that motion to support that allegation?
Your Honor, it was just signed by the attorney. There was not evidence cited other than they referred to public records, which were referred to but not enclosed with the motion, Your Honor.
But under 1540, I mean, if you're going to, before you can be entitled to an evidentiary hearing, there has to be some evidence submitted that might be in dispute, right?
Well, and Your Honor, there was an issue in dispute, and my understanding in the response, and that is whether there was a joint venture in the first place. I think that it is sufficient, based upon my understanding, that you make allegations in there, and if there are disputed issues of fact, which there are, that there should be an evidentiary hearing. If you make an allegation that the contract is void, and you tell the court why the contract is void, which was done in this case, and with particularity, I don't think you have to sit there and have to attach affidavits. In fact, the case law cited in the brief refers to cases where that once once a party moving under Rule 5.4 raises a colorable entitlement to relief, exercising that discretion requires holding an evidentiary hearing. And it says further, neither the submission of affidavits nor argument of counsel is sufficient to constitute an evidentiary hearing. And the point I'm saying, Your Honor, I think that once you set forth a ground, you do not have to attach affidavits to support it. I think that it's sufficient to just go ahead and let the court rule on the issues as you've raised. And I would like to reserve the time I have, and I forgot to do that. Okay.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court, my name is Frank Shaw, and I'll be representing the Appellee North Florida Construction Builders. Planned a little differently, but I think I'll jump in right into the issue of the order denying motion for final judgment. As this court's mentioned, that order was not properly appealed. I'm in agreement that 9.19 Appellate Rule 9130 would require that to be separately appealed. I found very analogous cases and was prepared to discuss them. And I'll mention those. I think this court's already discussed it a little bit, but the cases mentioned by the appellant are very distinguishable in cases that are not similar to what we have here today. Not cases with final orders that were, and then these cases we have wrong distinction, premature. This case we have a final order that needs to have been separately appealed, rendering or just, I guess, taking away subject matter jurisdiction of this court. And I think what's important here is the evidentiary hearing that was noted is a relief that cannot be granted. We can't go back to that now that we've failed to appeal the order that's denied that. The case that was consistent and very on point with this ruling, a separate order that was relief, a 1.54 case is, I'm going to have a hard time saying the name, but Park Homechuk versus A338 Southern 3rd 397.
Can you give that one more time? I'm sorry.
And I might just...
You don't have to pronounce
Okay, I'll give you the
title, just the site.
338 Southern 3rd 397.
Thanks.
And there was one more. Both of these affirmed each other. University of Miami versus Jones. This was a 3rd district case, but it was 338 Southern Third 401. I believe these are more analogous than the cases cited by the appellant, stating that the courts lack subject matter jurisdiction as it applies to that order, and the arguments made in the motion for that order, and also what's relevant here, the relief sought.
Well, so if we assume for a moment, in which you'd have to, because the Constitution says so, we have jurisdiction to review final orders of the trial court. Is the requirement that there be a separate notice of appeal for each final order
I would argue.
jurisdictional?
Yes, Your Honor. I would argue that you would need a separate notice of appeal.
And what is the basis for that assertion?
I believe that
Like
would be, well, appellate rule,
You don't have, I mean, it's okay, you don't have to cite that, you don't have to know it from memory, just give me what your understanding of the rules are.
well, my understanding would be the appeal has to be based on something that's been ruled on. So the notice of appeal in this case was entered but prior to the order that we're discussing now, months before. I think the order was rendered in August. The final judgment was rendered in March and appealed several days later, or notice of appeal was filed. And I think what you're getting at is that is what was appealed because the judgment was already rendered. You can't file a notice of appeal on something for an order that
Sure,
has not been rendered.
but they did invoke the court's jurisdiction with respect to
Absolutely.
the underlying, the original final order. And then they filed a motion to relinquish jurisdiction, for better or worse, to have this motion to vacate the judgment heard, and you didn't oppose it.
I did not, Your Honor.
Right. And so then jurisdiction was relinquished, they go down, they get the order. We didn't hear any opposition when there was supposed to be a supplement, and it was supplemented, and the order comes up, it's filed. There's appendices filed and all kinds of stuff filed. I'm having a hard, so I understand, so jurisdiction, like the 30-day requirement, for instance, is jurisdictional, and that's because the Constitution gives the Supreme Court the authority to establish a rule for timeliness of appeals. In this situation, we don't have, it's not necessarily a question of whether it's a timely appeal. Maybe it is, or an alternative, what your opposing counsel said, it was a premature appeal. Maybe not artfully done, and I'm sure if they had to do it over again, they may have done something a little bit more specific. But here we are, and we do have 9040 that says that we have jurisdiction to consider, everything necessary for complete determination of the cost. Help us out on that. And then, like I mentioned to opposing counsel, 9110H, which talks about we can only review orders that happen before the notice of appeal is filed. Isn't there a tension on that? How do we resolve that tension? I'm sorry, that was a convoluted question. More simply, we're here. Like, they did file notice of appeal. It was timely. They paid the fee. They just didn't appeal all the orders that they wanted to appeal. There was another final order that came after that they didn't file a separate notice of appeal of, but we invited that, file a supplemental record, send up your other order, and now that's before us too. Both sides have briefed it. There doesn't seem to be any prejudice. It's just a question of whether that separate filing of a notice is jurisdictional to preclude us from considering that in other order.
I understand, Your Honor, and I think that is a good point substantively. And I would argue that because the merit, I guess on our side, there was no distinction of what was actually being appealed in the notice for my client. Was we understood the final judgment to be appealed. In preparation for that was the illegality of the contract, the argument, the 1.45 argument, or 54 argument. And without the order setting aside, we are not on notice of the exact, I guess exactly what is being appealed is changing and is changed how they've moved. So when they initially appealed the order, that was based solely on that 1.54, and now we move into this we need an evidentiary hearing, which has changed the relief sought and the nature of the appeal. if you
Sure,
will.
merits we'll get to in a second. I won't belabor it too much longer, but I'll.
Right,
I'm
and I
sorry.
wanted to jump in right there. So
Yeah,
Judge
go ahead.
Tannenbaum picked up on 9.040, and we can exercise jurisdiction necessary to determine the cause. What is the cause here? Is it the first judgment, or is it everything else that happened afterwards?
I would argue the final judgment is that it is the cause, is the foreclosure is the cause. The defaulted facts that are in the record that are accepted by the appellant are the cause.
All right, and let me throw a hypothetical at you. So if I had a marital dissolution case where, you know, the parties were, you know, they awarded alimony, right? And that's appealed. And then while this appeal is pending, the parties go to modify alimony, and they get another judgment that, you know, modifies the alimony. Is that, which one, you know, can we just bring that second judgment right into that first appeal? Is that necessary to determine the cause?
I think so, because I do think it's necessary to determine the cause, but I do think a notice of appeal is required because it's changing what's being appealed. When the first notice of appeal was filed, it is strictly a argument that there was a joint venture and that no contract was valid here. But then it completely morphed into we needed an evidentiary hearing and raised the colorable entitlement. So I think that's the nature of the appeal changed, and that's what required a notice of appeal.
Do you think it's fair to characterize a notice of appeal as basically, it's the appellate pleading? I mean, it's, you know, a notice of appeal is just a piece of paper, I mean, it's like one paragraph, I know it's not fancy, but it does have significance, right? I mean, if you don't file the notice within 30 days, you're done, unless it's a criminal case, and that's a whole different matter. But isn't a notice of appeal basically your pleading? So when you attach, the appellant's pleading, you file a notice of appeal, you have to identify by rule, you have to identify what order you're seeking review of, and you have to even say like what type of order it is, and you have to attach it. Is it fair to say that that's your pleading, and so the cause is tied to whatever your pleading is at that moment?
Correct. So I think as I follow, when you file a notice of appeal, it's somewhat like your complaint, and you need to cite what the complaint or the notice of appeal is actually appealing. And here we have a notice of appeal for the final judgment, but we don't have that for the order that we're discussing.
Could the notice of appeal be amended? Like, could they come in and file a motion to amend their notice of appeal to add a subsequent final order?
I would assume so, Your Honor, but I've never amended one.
What about on the merits? Let's
Merits.
go right to the.
Yes, Your
what
Honor.
everyone was probably originally prepared for.
Well, I did.
Seems like everyone's raring to go on that. So on 1540,
So
on this motion, is there an obligation? Well, first of all, is this even a bona fide 1540 motion
No.
in the first place?
Well, is it a valid 1554?
I mean, they cite the rule, but what they argue in the motion, does it fit within the rule as a bona fide 1540 motion for relief from judgment?
No, Your Honor. I don't believe that it's a void judgment, and it follows that, and it falls back into because we have a valid contract. So we do not have a bona fide 1.5.
Now, do you say it's a valid contract because she's effectively admitted it's a valid contract by the default, or is there something else that you're relying on?
Your Honor, I would argue that we have the appellant, the owner, we have a general contractor, and we have my client who's an authorized contractor, all three on the contract. We don't have a joint venture agreement. There's no evidence to such. The only evidence we have is that contract, and I've actually filed an authorization form as my client operates as an authorized agent of Florida Builds, the general contractor.
In what context was that filed?
That was filed, Your Honor, subsequent to the final judgment, and I think that it kind of goes back to our argument in the order. That changes the appeal. I wasn't on notice that would be really necessary for the initial final judgment. That argument wasn't raised, and that kind of goes to another point I made in my answer brief that, like Your Honor's mentioned, we have a complaint, a default, service default, no affidavits, and summary judgment. And this court and the Supreme Court have waived that these affirmative defenses are waived at that point. So we get to a point where the defense is trying to make these arguments and going for anything the judgment is void and trying to backtrack into, well, the contract is void. And I think that even leads me into the colorable entitlement. I don't think they raised a colorable entitlement because I think it was just an argument made plainly without anything presented, any evidence or support to that point. And that is the exact reason why we have the requirement, is to keep cases like that out of a hearing.
I'll wait. I'm sorry. I'm asking a lot.
Go ahead.
Did you find a single case where a 1540 motion was used to get relief from a default judgment?
I did not, Your Honor.
And on the argument about the let's assume, like, the statutes that were cited by the appellant, is there a single provision in any of those statutes that established that the contract would be void? Maybe other issues, but that a contract that they enter into is void as opposed to voidable?
Not-
Do you
not-
make a distinction between void and voidable?
Your Honor, not void. I saw the words unenforceable and voidable, but void. no.
Sure. And those have legal distinctions, right?
Correct, yes, Your Honor.
What's the difference between a void contract and a voidable or unenforceable
I
contract?
believe a void contract has no legal effect at all. It's void from its initiation, does not create a meeting of the minds or any kind of relationship between the parties. But a voidable does. I believe one party, though, can opt out, or one party can
Waive the claim
waive the
that it's
claim. Okay.
voided, right? Now, can 1540 be used to get relief from a judgment on a void contract?
On a void contract, yes, Your Honor, I believe so.
Okay, what about on a
No, Your
voidable
Honor.
contract where the defendant has already effectively, or as a matter of law, admitted to the enforceability of the contract?
No, Your Honor, that is not a avenue of 1.54, which you're mentioning. So I think that we fail in the defense motion and appeal fails to meet that threshold of a void judgment because we have a voidable contract, maybe, arguably, a voidable contract, though not a void contract.
Given that status of the law, was there a good faith basis to bring this appeal?
It's hard to say. I don't believe so, Your Honor. The case went, I think I'm not really, I don't think so, Your Honor.
And let me ask it differently. Is there any legal basis that would support the bringing of the appeal under the circumstances of the default here?
I would argue no, Your Honor, and also argue factual circumstances as well. I think that it was almost hard to prepare for it, and that it was not, and I didn't know which direction we were really going in at times. But no, I would say that legally and factually there was no basis for it.
Is there an obligation, if one is gonna file a 1540 motion, and there's a desire to have an evidentiary hearing, is there an obligation to submit evidence in the first instance?
Your Honor, the cases that were cited, I don't think required an obligation to submit. However, they did, and they were very factually driven. It was the first one on my top of my head was notice. I think that's a big and important part of that, because here we simply just have the defense trying to avoid, or appellant trying to avoid the foreclosure and just saying there was a joint venture with no backing. We don't have an affidavit from the other general contractor stating that. We don't have any we don't have any kind of even allegation to that matter, or not even, regardless of evidence. So I don't think there's a requirement, Your Honor, but I do think I wouldn't file one without it. And if I wanted to really get an evidentiary hearing, I'd mention it.
Is there entitlement to fees under this, in this case?
Mechanics, Chapter 713, Your Honor? Yes, Your Honor, there is entitlement to fees.
And did your client receive fees, or were they awarded fees?
They were awarded
trial
fees in the
court?
foreclosure, yes, Your Honor.
Right. And I didn't go back to check. Have you filed a motion for fees here?
Not in this yet.
Okay. And you didn't seek sanctions either?
No, Your Honor.
Okay.
court has nothing else, I'll just ask that they affirm the court's lower decision, and that's it. Thank you.
Thank you, counsel.
I have 2 quick points to make. First one is this, I think you were talking about voidable contracts and void contracts. In Florida, a contract that is for work done by an unlicensed contractor is unenforceable, period, end of story. Earth Trades versus TG Corporation, 108 Southern 3rd, 580, Florida Supreme Court, 2013.
Is unenforceable the same as void?
It's void, Your Honor. It's not enforceable, period.
Well, no, those are two different things. Unenforceable is not void.
Well,
Unenforceable is one thing, void is another.
If you look at the statute says, the statute specifically holds that, the contract may not be enforced nor a lien enforced either, Your Honor, from work done by an unlicensed contractor. Now, you can say that.
Could someone accept that, though? I mean, could your client just waive that
Well-
argument and accept the lien?
I mean,
and its enforcement.
I believe the case I cited to you said that, which was about being a void contract as opposed to a voidable one is appropriate, Your Honor. I bring that to your attention that way. You know, that's my response to it.
I mean, what do you make of the, I mean, I'm still having a hard time squaring this idea that it may be unenforceable, but your client accepted the allegations, the complaint, accepted enforcement by not defending and taking the default.
And Your Honor, again, citing to you the City of Hialeah case versus John L. Adams and Company, 599 Southern 2nd, 1322, the client there accepted the work and did it, and nobody raised the issue. It wasn't for work, but it was for a bid on using public money, and it was a court-imposed public policy issue. But nobody in that case raised the issue. In other words, there was no complaint about it, and it was not raised in the pleadings. And the court still said we have authority to find that this is a contract in violation of public policy, and it's considered fundamental error. So you are correct. There's no dispute that our clients accepted the services. Of course, they didn't know that this person was an unlicensed contractor. That was found out later.
How would that have affected her?
Sir?
How would that have affected her? Is there anything in the record that indicates that the reason she didn't pay the bill that she incurred?
Not that I saw, Your Honor. No, sir, I did not see anything. There was a letter of complaint that you probably had an opportunity to read that said that they weren't giving me bills. I didn't know who was providing the work and that type of thing. But can I sit here and point to you and say that she was damaged? No, I can't, Your Honor. I mean, I can't tell you that. I'm just telling you that when you, if I have just a moment.
Certainly.
Yeah, I'm suggesting to you that if the contract is void, the case is holding that saying, we're sorry if somebody gets hurt, whether it be the contractor or the homeowner, whatever it might be, it doesn't make any difference. And it's not an issue of damage is what I'm suggesting to you.
Thank you, counsel.
Thank you.
Thank you all. This court will adjourn.
Thank you, Your Honor.
All rise.